What about the government? The government says...
The government doesn't say shit, mate.
Well, it does. I've got the documents.
There's no charges, mate.
I know, but the government...
Well, there you go, you know. Fuck off, mate. Yeah, keep going. Otherwise I'm going to fucking come out there with a baseball bat and fuck you up. Yeah. Fuck off, mate! Fuck off!
Alright, yeah.
Fuck off, mate, alright?
We're leaving.
I was so angry and so frustrated because I'd spent 3 years begging people to help. And my little boy paid for their ignorance.
But despite concerns from their school, from neighbours and from other family members, Braden never made it home. Who did you try to raise the alarm with, and how did that go?
I took many trips back and forwards to Canberra. I spoke with the police, with the Child and Protection. Every card that was offered to me, I rang them on daily basis, on weekly basis. I was going into the police station.
And what sort of response were you getting from the police and from the care and protection system?
Absolutely nothing. I was ridiculed, I was mocked, that I was wasting their time.
The decision was made to quietly move Jacob to Queensland and in with his father, a man he'd barely seen in 10 years, had next to no experience in dealing with diabetes, and who the government's own record stated that, thanks to an extensive criminal history, posed a significant risk to Jacob.
To say I was surprised just doesn't remotely reflect that staggering news. It seemed to me that there had to be a mistake because the Care and Protection Service had been so clear that Jacob should not be placed with his father because it presented a significant risk to him.
The Directorate did later apologise to Catherine for moving Jacob in secret, but the damage was done.
It's worth noting the public advocate slammed the then minister, saying that care and protection had breached the law 24 times, which had a serious and detrimental impact on children for whom the Director-General had responsibility. That's right, Madam Deputy Speaker, it breached the law 24 times. Unfortunately, at that time, the then minister's response was not to address the problems identified, it was to get her own lawyer to disagree with the findings.
But the previous public advocate who was bullied because she dared to question what was going on in the care and protection system. The previous public advocate who was bullied because she dared to say that she believed that what was going on in the care and protection system was a breach of the law, 24 breaches of the law that she identified. But she was bullied over that. And I think that's why the public advocate has even fewer resources now than the public advocate did in 2012, because the government didn't like hearing what they heard.
Excuse me. There is a growing body of evidence suggesting that parents with cognitive disabilities are subjected to a higher rate of child protection intervention and child removals than parents without disabilities. Allegations are that the high rates exist because of issues of prejudice, discriminatory attitudes and a severe lack of appropriate parenting supports. If this is the case, then the ability and capacity for external review to occur is even more paramount. For almost a decade, disability advocates have highlighted concerns regarding the disability or disproportionate removal of children from their care of their parents where one or more parents have a disability, particularly cognitive disability. And it's suggested that children and families who come in contact with the child protection system often share common marginalisation and demographic characteristics. Parents with cognitive disabilities are overrepresented in the child protection system and face significant barriers to equitable participation in the legal processes arising from this. We must be sure that decisions made about the placement of parents with disability are fair and unbiased.
And there are a number of occasions that I have personally dealt with, which I can't talk about in detail, but I can tell you that I have received briefings that, Mrs Dunn, don't you worry, this is all perfect, this has happened and that has happened. And when you get back to the family, you discover that those things haven't happened. I've had confidential briefings where I've had to call the departmental staff back in to account for why they told me one thing when it wasn't true. And that happened more than once on my watch. And I'm sure that it happened when Ms Lauder was in the position, and it will, and Ms Kikkert's new to this position, but I will lay you quids that before her term as the Shadow Minister is out, she will find a circumstance where she will have to call back someone who has given her a confidential briefing and ask them to clarify. And then they will sit there shamefacedly, go all red in the face and say, oh, well, it wasn't really like that. That should never happen. That should never happen. And the
And a caseworker sent up from Canberra was too frightened to meet with Jakob's dad. The matter was then also quickly flagged with the ACT's Children's Commissioner, whose investigation was no less scathing of the Territory's handling of the case. Rather, in April this year, and in an effort to further cut costs, the government rolled the Public Advocate and the Children's Commissioner into the one. Some lost their jobs, others quit in disgust. And Queensland's Public Advocate, Jodie Griffiths-Cook, was brought in to try and make it all work. But there is
revealed ACT authorities receive an average of 19.
The government admits the solution
in the cases examined in this latest review, it appears since 2002 reports of child abuse have been on the rise, and the actions allowing authorities to drug test the government's handling.
There is nothing new here. Almost every year in Canberra brings more tragedy, more inquiries, and the promise of more money.
Why would we wait when the risk is that another tragedy like the one that prompted the Glanfield report could well occur in the meantime?
From the Glanfield inquiry, and I wish to acknowledge the work that is being done in those areas. They are all important. At the same time, I and many others in our community remain significantly concerned about one issue in particular. Like many Canberrans, I was troubled recently by news reports of a young person in a territory who was being pressured to drop a domestic violence order against one of her former foster carers. This case was brought to public attention by Bill Bashford, who earlier this year resigned in frustration from his role as one of 3 official visitors for children and young people appointed by the ACT government. Perhaps more troubling than the details of this specific case, however, was Mr. Bashford's account of what he experienced when he raised his concerns. He claims that his complaints to Child and Youth Protection Services, or CYPS, were first ignored and then dismissed. When he finally got a response 3 months later, he was only told that the matter had been handled in accordance with internal protocols and that he was not entitled to any further explanation. Madam Assistant Speaker, some may wish to dismiss Mr. Bashford's frustration, but I can assure you that these experiences are not isolated ones. I have heard nearly identical stories shared by dozens of similarly frustrated families and carers. Decisions are made without clear explanations why. Request information are refused. For many who interact with the system, matters at CYPS appear to be decided under a cloud of protective secrecy and with an air of absolute infallibility. And when those directly affected find themselves in serious disagreement with decisions made, they often feel they have nowhere to turn. In light of the growing number of Indigenous children receiving child protection services in the ACT, and in the face of what he has labelled the arrogance of the system, Mr. Bashford has recently asked for an independent Aboriginal community body to oversee Indigenous children in care in the ACT. In a similar vein, Julie Tongs, CEO of Winanga, has proposed the appointment of an Aboriginal Social Justice Commissioner for the territory. In both cases, the wish is to have someone external to the system to whom people can turn. I feel confident that the dozens of worried and frustrated Canberrans who have contacted my office would agree that we desperately need an independent body to oversee the decisions that affect our children in care and protection, their families and their carers. This desire is not misplaced, Madam Assistant Speaker, or new. The lack of external review for CYPS decisions has been a known flaw in the Territory's child protection system for too long. 13 years ago, the Varden report noted that, quote, parents, carers and agencies all relayed stories of frustration about having nowhere to go when they disagreed with family services, the predecessors to CYPS, about such things as placement decisions and care plans. The consensus was that an independent mediator was needed to deal with these disputes. The report's preferred recommendation, supported by both magistrates and legal representatives, was the appointment of a Commissioner for Children and Young People who would chair an independent tribunal to review a decision made by government-funded services dealing with children and young people. The Human Rights Commission Act created the position of Children and Young People Commissioner, but ignored the Varden report's recommended tribunal, and likewise failed to provide the Commissioner with specific jurisdiction to review CYPS decisions. The functions of the office to include encouraging the resolution of complaints, but this is not proper administrative review. Moreover, the situation in the Territory has been so dire that Alistair Roy, the Children and Young People Commissioner from 2008 till 2016, eventually gave up even trying to help resolve the most complaints. And the Canberra Times reported in 2013, quote, families and young people who complained to the ACT Human Rights Commission about their treatment by care and protection services are being referred back to the Directorate because the Commissioner does not have the resources to deal with their complaints. Just last year, current Commissioner Jodie Griffiths-Cook told the ABC that it was common knowledge that her office was dangerously overworked and could not provide even basic oversight. Another failed opportunity to address this issue passed in 2008, with the creation of the Territory's much-needed Civil and Administrative Tribunal, or ACAT. Subsequently, certain CYPS decisions were identified as merits reviewable in the ACT, but as last year's Glanfield inquiry insightfully notes, a number of important decisions, such as care plans, the amending of care plans, and the decision not to provide information to a child's parents were not included. I have to assume that these omissions reflect the long-standing unwillingness of Labor governments to allow for rigorous oversight of these decisions. The purpose of a tribunal is to provide for simple, inexpensive, quick and fair resolution of concerns, thereby enhancing the quality of decision-making under legislation. As the Australian Administrative Review Council has noted, access to external review, quote, improves the whole system of government decision-making by increasing its openness and transparency and providing feedback on its performance. In the words of Justice Deirdre O'Connor, he, quote, confident executive government should welcome this kind of audit, close quote. Tribunals provide an attractive alternative to judicial review, which can be inaccessible to many people because of complexity and cost. But the situation in the ACT is even more complicated than that, Madam Assistant Speaker. The Glanfield inquiry specifically points out that decisions regarding a child's placement are legally not subject to judicial review in this Territory pursuant to the Administrative Decisions Judicial Review Act. All of this has left parents, carers and agencies exactly where they were 13 years ago when they unanimously shared with the Varden report their frustration about having nowhere to go and their desire for an independent mediator. Amongst those who have joined the swelling chorus of voices calling for some form of external review of important CYPS decisions is former Children and Young People Commissioner Alistair Roy, who told the Glanfield inquiry, quote, "I consider that the availability of administrative review of such key decisions would improve accountability for decisions that have a significant impact on the lives of children and young people and their family and carers, and would promote high-quality, evidence-based decision-making by CPS, which is now CYPS. Another powerful voice has been Legal Aid ACT. In their submission to the Glanfield inquiry, they directly identified the lack of an external oversight body for CYPS decisions as a threat to child protection. They then recommended that the Territory follow other Australian jurisdictions by giving ACAT responsibility to review important CYPS decisions, including where children live and whom they have contact with. Legal Aid suggested in particular that Western Australia offers an especially robust model to follow, providing both independent internal review and external administrative review. As noted by Legal Aid, current internal review at CYPS does not meet the standard recommended by the Australian Administrative Review Council. And even if it did, quote, internal review without access to external review does not provide accountability. Madam Assistant Speaker, when parents, carers and agencies are joined by Legal Aid ACT and former Children and Young People Commissioner and a former official visitor for children and young people, then it is well and truly time for the ACT government to finally listen and make changes. The Minister has noted that child protection workers deserve the ACT community's full support. I couldn't agree more. They have incredibly difficult jobs. I therefore want to emphasise that the concerns I have shared today are not because either citizens or experts do not appreciate our territory's child protection. Rigorous internal and external review mechanisms are essential to provide the support and protection needed for those who daily engage in this kind and difficult work. The Minister has told us this morning that representatives from both JACS and the CSD have been meeting to consider what decisions made by CYPS should be subject to enhanced internal or external review. I am satisfied that this important analysis is in progress and hope very much that it will not take much longer. It has already been 16 months since the recommendation for this review was issued. No doubt those involved wish to be both thorough and cautious, and they should be. At the same time, I would like some assurance that this time is one that has been prioritised by the ministers who oversee these two directorates. I would also like to be assured that issues of contact, though very important, are not the only ones being considered for potential changes regarding review. In the meantime, the Minister has tried to assure us this morning that other established independent mechanisms are already in place to perform oversight and external scrutiny functions of the child protection system. Madam Assistant Speaker, if these established mechanisms were functioning as needed, we would not have so many recommendations suggesting that we need more and better review of important CYPS decisions. The Minister has mentioned the Children's Court and other courts. I remind this Assembly of the Glanfield inquiry's conclusion that decisions regarding a child's placement are legally not subject to judicial review in this territory. The Minister has also mentioned the Office of the Public Advocate and the Children and Young People's Commissioner. I remind this Assembly that the former Commissioner threw up his hands in despair and stopped dealing with most CYPS complaints in 2013, and that the current Commissioner has publicly noted her inability to handle all the complaints her office receives. I sincerely hope the additional funding being provided to this office helps to alleviate this incapacity. But even a less overworked commission is still an oversight mechanism, not the repeatedly recommended review mechanism. Last The Minister mentioned that some administrative decisions are reviewable by ACAT. Madam Assistant Speaker, this is at best an attempt at deflection. As Mr Glanfield himself clearly stated in his report to the government, the most important decisions, such as care plans, the amending of care plans, and the decision not to provide information to a child's parents, the very decisions, in fact, that are central to people's concerns are precisely the ones not currently reviewable by ACAT. Madam Assistant Speaker, for far too long, successive Labor governments in this chamber have turned a blind eye to concerns raised by parents and carers. Perhaps they thought such people are too simple to know what they are saying. But increasingly, experts in child protection have voiced the same concerns. If the mechanisms that are already in place were enough, we would not be having this discussion, and we most likely would not have needed the Glanfield inquiry. The Minister has this morning foreshadowed the possibility of future changes. All I can say is it's about time. In fact, why has it taken so long to seriously address this issue? Whenever children are potentially at risk of harm, I expect this government to act with urgency. Thank you.
Joining us today in the gallery, a former member for Ginninderra, Dr. Chris Burke. Dr. Burke, on behalf of the members here, a warm welcome to you. A question.
We're talking Canberra, 2CC, we're talking Canberra.
A 2CC Tim Shaw podcast.
I'm pleased to say that Dr. Chris Burke is the Minister for Children and Young People here in the ACT. He's across the commentary that Mr. Oakey, the grandfather of Jacob Oakey, has just told us. He's on the line now. Dr. Burke, good morning.
Good morning, Tim.
We're not getting transparency and straight answers from the ACT government, according to Jacob Oakey's grandfather, Alan Oakey. What do you say to that?
Look, I'd say at the outset that any child's death is a tragic occurrence. It shocks and saddens both families and the community, and I know that from my own family's experience. What I would say is that it's very important to understand why we have secrecy provisions around caring for children and young people. It's because it's vitally important to protect the privacy and personal circumstances of those children.
Minister, Jacob is dead. Jacob is dead, Minister. His grandfather will not accept, and nor will this program, the inability of the... That is not acceptable. That is not acceptable. Chris, Minister, you have a responsibility to communicate with the members of the family. We have a grieving mother. We have a grieving grandfather and grandmother. They have had nothing but barriers from the ACT government. Privacy for Jacob has gone, Minister. It's in the public domain. What do you want to say to Mr. Oakey and his family?
As I was saying, Tim, if you were aware of the circumstances of families in these situations, you would be aware that there are always invariably other children whose privacy and personal circumstances need to be protected by the privacy provisions of the Children and Young People's Act. It is not simply possible to breach that Act without hurting and harming other people.
Mr. Oakey is in receipt. Mr. Oakey is in receipt of documents that they've received under Freedom of Information. His statement to me this morning is clear, that the ACT government has redacted those documents to such an extent that they can't even see clarity, and they are the direct family members. Sir, what are you going to do about it? Mr. Oakey demands answers, expects answers, and deserves answers. His daughter is devastated. What are you going to do as the responsible minister?
No child, as I said, Tim, wants its family circumstances discussed in the media, and I'm very clear about
that. That is unacceptable, Minister. It is in the public domain. It has appeared on ABC television in an extensive documentary. Mr. Oakey has contacted this program. Mr. Oakey is Jacob's grandfather. What are you going to do today? What are you going to do today?
Tim, you are only hearing one side of
What
the story
are you
here,
going to do today to a grieving family here in the ACT, Minister?
As I said, Tim, this child deaths are a tragedy. I know that from my own family experience. And what I'm also telling you is that the integrity of our child protection service, of the circumstances...
That is unacceptable, sir. The child is dead. The child is dead. The family are demanding answers. Your government has redacted those documents to such an extent that Mr. Oakey can't even see the woods for the trees. Have you spoken directly to Mr. Oakey?
There has been considerable correspondence.
Have you spoken directly to Mr. Oakey?
Office. There is and I think one of the things that you're losing sight of...
I'm not losing sight of anything. We have a dead child that was the responsibility of the ACT government. You are hiding behind bureaucracy. Shine the light.
And you know that.
Shine the light on this and open the door, Minister. The child is dead. The family are demanding answers. Will you give a commitment on this program now that this matter will be on the agenda for the last cabinet meeting of this government before you go into election mode?
Thank you, Tim. And of course, the final cabinet meeting for the ACT government prior to the election is today, and
yes.
I will be providing with cabinet with an update on the progress of issues, support structures and oversight mechanisms operating in the child protection space. You must remember also that we're 18 months into our $16 million 5-year step up for our kids reforms, which is of course supported by Cabinet. You'll also recall that there was $2.47 million in the current budget to improve oversight and quality assurance in child protection.
Sir, don't tell me. Tell Mr. Oakey. You go to that cabinet meeting, you speak to your cabinet, and then I would strongly urge you to speak to Mr. Oakey. Thank you for your time, Minister. I appreciate it.
Well, I'm sorry that... by the way, Tim, it's also Child Protection Week.
Yes, I know. I've noted that.